In Indian polity, we are going to discuss about the criticism of fundamental rights. Okay, so it means each and everything has positives and negatives. Okay, so in this class, we are going to discuss about criticism of fundamental rights. So the first one is excessive limitations. Okay, so our constitution provided some important fundamental rights to each and every person in India. Okay, but there are some excessive limitations, exceptions. Okay, restrictions, explanations, qualifications. There are so many qualifications, there are so many explanations, there are so many restrictions to the fundamental rights. Okay, so the critics are says constitution grants fundamental rights without with one hand and takes them away with the other hand. Okay, it means the constitution granted fundamental rights with one hand, that is part 3, but takes them away with the other hand. Okay, it means they are taking away the fundamental rights in the name of limitations, in the name of exceptions. Okay, in the name of some restrictions. Okay. Okay, so J.R. Kapoor said fundamental rights should be renamed as limitations on the fundamental rights. Okay, so it means there are so many limitations in the fundamental rights. That's why, so there was a criticism by the J.R. Kapoor. So we can, it means it is renamed as limitations on the fundamental rights or fundamental rights and limitations. Thereon. Okay, it means there are so many limitations. That's why this is one of the criticism of the fundamental rights. So next important criticism is there is no social and economic rights. It means the fundamental rights is not comprehensive. It is mainly consisted with political rights. Okay, it is mainly consisted with political rights. There is no social and economic rights in the fundamental rights. Okay, so here what is social and economic rights? For example, right to social security, right to work, right to employment, right to rest. So these are the social and economic rights, but there is no provision related to the social and economic rights in the part 3 of fundamental rights. Okay, so these rights are available in advanced democratic countries or a socialist constitution like USSR or China. Okay, it means right to work, right to employment, but in India, so there is no provision related to the social or economic rights in the part 3 of the constitution. And next important criticism is there is no clarity because our constitution is a very complicated language. So the beyond the comprehension of the common man, beyond the knowledge of a common man. Okay, so it is very complicated to read the provisions or articles in the constitution because the constitution is made by the lawyers. Okay, so the constitution was made by the lawyers. Okay, so here there was another critique, it was made by the lawyers for the lawyers. Okay, so this was a criticism towards the fundamental rights. And next one is here Sir Ivor Jennings, he said constitution of India is a paradise for lawyers because it was created by the and it was made by the lawyers. That's why our constitution of India is a paradise for lawyers because we cannot read that complicated language, but lawyers can do. Okay, so that's why this constitution of India is a paradise and it is only useful for the lawyers. Okay, so next one is no permanency. There is no permanent law in the constitution, so it means they are not sacrosanct or immutable. They are not sacrosanct and immutable. Okay, because parliament can curtail or abolish or remove any provision in the constitution at any time. Okay, so for example, article 31, So it is a right to property. So the right to property was repealed by 44th Constitutional Amendment Act 1978, and this was the status, it means the legal right status was given to the Article 31. So and the new article was added, that is Article 300A. Okay, so it means the article right to property was removed from part 3 to part 12. Okay, it means it given the status to legal right. Okay, and it removed from the fundamental right and it was added into the legal right. It means parliament can curtail or abolish, or it can remove any article, any provision, any feature from the fundamental rights also at any time. Okay. Okay, so here removing or adding any provision in the constitution is a tool in the hands of politicians. Okay, if the majority supports in the parliament, so the particular provision can be removable. Okay, so it means the main important tool in the hands of politicians. Here the majority will speak. Okay. Okay, so here the judicial innovated concept, that is the basic structure of the constitution. Okay, so in this concept it is only one limitations on the parliament's authority. Okay, to remove any article from the fundamental rights, because this was concept which was created from the occasion in the Bharati case. So that's why the basic structure of the constitution cannot removable by the parliament authority also. Okay, so each and every person can enjoy the fundamental rights. Okay, but the fundamental rights also can suspend during the emergency. Okay, so here suspension of the fundamental rights enforcement during the national emergency, except Article 20 and 21. It cuts the democratic system at a roots level. It means innocent people also can suffer with the continuous jeopardy. Okay, so it means innocent people without any interference of the people also can suffer with this jeopardy. Okay, so except 20 and 21 articles of the part 3 of the Indian Constitution, the remaining fundamental rights are suspended during the emergency, especially national emergency. Okay, so here some critics are saying fundamental rights should be enjoyable in all situations. So, irrespective of emergency, no emergency, there is no need to stop our fundamental rights in any situation. Okay, so it means fundamental rights means each and every person has responsibility to enjoy those fundamental rights, but there is no limitations to the fundamental rights. We can enjoy all fundamental rights in all situations. Okay. Okay, so if any fundamental rights is affected by the state or government, so in that time the judiciary has a responsible for defending or protecting those rights. Okay, so if anything is wrong in the legislative body or executive body, so the judiciary has a responsibility to keep an eye on the legislative and executive bodies, right? So in this process is very too expensive. Okay, so for the poor and common people it is very difficult to enforce them through the courts. Okay, so maybe rich people can go to the courts for the enforcement or protecting their fundamental rights. Okay, so it means rich people can success by using their money. Okay, whenever comes to the poor or common people, it is very difficult to enforce the fundamental rights through the courts. Okay, so here also critics are saying the rights benefits mainly by the rich section of the people. Okay, so the rights cannot give the benefits to the poor people because the process is too expensive. Next one is preventive detention. Okay, so this provision takes away the spirit of fundamental rights. Okay, but basically, so it confers the arbitrary powers on states. It means it is neglects the individual's liberty. Okay, so the critics are saying Constitution of India deals more with the rights of state against individual than with the rights of individual against the state. Okay, it means mostly so many rights are against the individuals from the government side. Okay, but there are only few rights of individuals against the state. Okay, so no consistent philosophy. So basically the fundamental rights is not a product of any philosophical principle. Okay, it means there is no consistent philosophy, and critics also says this creates the difficulty for the Supreme Court or High Courts for the interrupting the fundamental rights. Okay, because it is not consistent philosophy, so that's why it is very difficult to interfere in the matters of the fundamental rights by the Supreme Court, High Courts whenever there is a issue of the fundamental rights. Okay,